Welcome to this video call on leveraging the benefits of free trade agreements. My name is Dan Kisselback and I'm a lawyer with Miller Thomson. I lead the trade and customs practice at Miller Thomson. And with me is Dave Pentland, Vice President of Carson International. We're delighted to have you here and glad that you've joined our session. And without further ado, I guess we should proceed. The first thing we've got is a disclaimer that this is not legal advice. I guess you have to expect that coming from a law firm, but moving on, Dave, maybe introduce yourself onto the next slide.
Yeah, good afternoon. I'm Dave Pentland. I'm the Vice President of Carson International. Pleasure to be doing another session with Dan Kisselback from Miller Thomson. We work closely with Miller Thomson on trade issues, both the import and export. And so I hope you find today's session informative, and it's certainly the tip of the iceberg on free trade agreements, but it'll get you started. And if you have any specific questions, certainly feel free to reach out to myself or Dan in the future. Take it away, Dan.
So this is just intended to be a quick primer on what's going on with free trade agreements and why do we care. This slide discusses the benefits of free trade agreement. One goal of a free trade agreement is to allow for what's known as market access. And market access means allowing exporters from one country who are importing into that country gain entry, their goods gain entry with less friction. What do I mean by less friction? Well, less costs, reduced or eliminated tariffs, or reduced or eliminated non-tariff barriers. Sometimes governments impose non-tariff barriers just as a fun way to make it difficult to import into their country, and it's a means of protectionism. So governments have entered into free trade agreements in order to boost the level of their exports into other countries, and many governments around the world are doing that. It's a strategy for boosting the economy, domestic economies. One study has indicated in Canada that 1 in 5 Canadian jobs depends upon trade. So what is the problem? Well, there's sometimes lack of uptake. Some importers don't know the rules. They don't claim the benefits under the FTAs. And sometimes that means that they're overpaying duties. So my takeaway from this presentation is it pays to be a winner. Importers can be strategic and find out whether or not they can take advantage of FTAs and eliminate costs. Over to you, Dave.
Yeah, I would just say, to put it in context, in 2019, Canada's GDP was about $1.7 trillion, with our population about 37 million people. And of that, our trade with the United States in goods was 718 billion. So about 40% of our GDP is made up of trade with the United States. So,
on to the next slide. What is a free trade agreement, FTA? Basically, they're treaties, and they're basically like a contract that's made between governments. There may be a treaty that is bilateral, that is between two countries or two regions, or multilateral, that is they're between multiple countries. Usually they're more complicated if they're multilateral treaties. They may deal with one issue or multiple issues. And the point of an FTA is to reduce protectionism, smooth out trade irritants, and encourage economic integration within a region. Say, for example, with respect to the USMCA or the CUSMA or the TMEC, as it's known in North America, there is greater economic integration as a result of having this type of an agreement within North America. And trade has grown substantially over time, having regard to the existence of what was known as NAFTA, now NAFTA 2.0. The days of the big blockbuster FTAs seem to be on ice for now. During the Trump administration, there was a focus on bilateral treaties, that is just agreements between the US and individual countries. and there was a lack of interest in multilateral negotiations. So it remains to be seen as to whether or not a new administration will, in the next year, focus on multilateral or stick to these bilateral negotiations. On to the next slide. Well, there's quite a raft of different agreements, eh, Dave?
Yeah, there's a list of the major ones, this slide and the next. So certainly these are the ones that are between certain countries other than the CETA. But I guess the big one that's in play right now is CPTPP, which that one is actually one of the biggest trade agreements in the world. So it's tying up 11 countries with a GDP of $13.5 trillion. And so this is the one that Dan mentioned that the United States actually was involved in heavily in setting it up. But after the Trump administration took power in 2016, the United States pulled out of the CPTPP. So everybody will be waiting to see if the United States wants to join this group again. So.
Yeah, so there have been varying degrees of success with respect to these FTAs. Obstacles have included, lack of awareness. Just generally, people don't know that there's a, Canada-Korea free trade agreement. And, oh, wow, that's important. We should probably try to take advantage of that when they learn it. Lack of expertise to claim benefits. And that's one of the things that brokers can add to the mix for importers is they can provide expertise in trying to structure imports in a way that minimizes duties and taxes. And then the cost of compliance. Sometimes if the amount of duty at issue is very low and the cost of compliance is high, there is an economic decision not to really bother with trying to certify goods or prove that they are eligible for free trade treatment, duty-free treatment. But those types of situations are often rare, and generally the cost of compliance can be managed.
Yeah, I should point out these two slides represent countries that are trading in goods. We've left off countries that are not involved in trading goods because there's certain FTAs that are in place that countries are trading in services or financial agreements or items like that. So from a broker's perspective, these are the countries that we deal with. Dan and his firm would be involved in other things where there's financial agreements in place, tax agreements, other things that are involved in free trade agreements that aren't specific to goods being imported or exported.
Yeah, from my perspective here on this wonderful list is the Comprehensive Progressive Agreement for Trans-Pacific Partnership, CPTPP. I would call that the TPP Light because it no longer involves the US. President Trump, as one of his first acts, withdrew the US from the TPP. It was structured in a way that froze certain clauses within the TPP with the hope that the US would someday come back and revisit the TPP and rejoin the TPP. So it's now called the CPTPP, and it doesn't have the US, but there may be some interest at a later date for the US to participate in this wonderful agreement. On to the next slide. There's a Tariff Finder that you can use to identify the agreements that may be applicable to you. There are other, I guess, more sophisticated programs that can help importers locate the most beneficial agreement to suit their purposes. And people like Dave would be able to kind of identify if you're sourcing goods from Vietnam and from China, what kind of agreements would be applicable? How could you manage the agreements in a way that would save you costs? On to the next slide. Trade and investment agreements. Well, in addition to the FTAs that deal with trading goods, I should say, other agreements help address investment issues to ensure that, for example, investors receive a fair shake when they invest in a country, that they're not discriminated against, that they have equal protection of the laws, and things work according to the way they should under the domestic laws. And there's a list of such agreements there. FTA considerations. Well, before entering a market that has a free trade agreement with Canada, you should consider a few factors. Determine what are the rules of origin. These are the nuts and bolts provisions of a free trade agreement. I would regard that as the heart of a free trade agreement. Determining whether or not the goods that you're intending to export or import will meet those rules of origin and become what we call eligible for preferential tariff treatment. That is eligible for reduced duty or preferential tariff treatment. And sometimes, most times, it's duty-free treatment. And in addition, there are rules with respect to the rules of origin plus proof of origin. And the rules of origin differ according to the free trade agreement, and the proof of origin rules differ sometimes according to each agreement. For example, under the CPTPP, I recall that you don't have to use a specific form like you used to have to use under the NAFTA agreement. You can use your own form. And I think Carson has put together a form, that handy-dandy proof of origin document that can be used to suit the case. With respect to government procurement, we're talking about opportunities for companies and businesses and persons that are outside of a country to take advantage of government contracts. And they're often very lucrative contracts. So it's a big deal in many cases to have these government procurement provisions. We're going to be looking with interest at the situation going forward in the United States to see whether or not government procurement is going to be restricted, having regard to what are known as the Buy America provisions. And there's going to be undoubtedly a interest in encouraging economic development and jobs in the United States. One way of doing that is to ensure that government contracts are supplied by Americans, or goods that are made in the USA, that kind of thing. So watch for that.
And I guess one comment there is that this was a primary reason that the Trump administration pulled out of CPTPP, is that they did not want to give away opportunities for American firms to quote on American jobs versus 11 countries as part of the CPTPP. And maybe another comment on the non-tariff barriers. Often countries protect certain industries in a manner that goes beyond trade agreements and has to be structured. I guess the prime one that comes to mind is with us in the United States. Canada has a number of marketing agencies and quotas establishment for dairy is a primary one where we protect the dairy industry. And so therefore that falls outside and it does protect, and I'm not going to get into whether it's wrong or right, but it keeps a set price for dairy farmers, cheese, milk, turkeys, chickens, things like that. So
I guess depending on which side of the border you are on, it's wrong or it's right. So David, that's part of the deal, I think. Yeah. On to the next slide. Intellectual property, this has been a very big deal over the last little while. Intellectual property protections are increasingly important for a variety of reasons. The makers of the intellectual property want to make sure that they get the benefit of their creation. And also people that are receiving particular types of goods want to know that what they're getting is what they bought. Sometimes there's concerns about copyright infringement, counterfeit goods, gray market goods, all these things. And governments around the world, including Canada and the United States, have taken a very serious look at enforcing intellectual property laws and ensuring that the destination market is not a magnet for counterfeit goods. Sometimes counterfeit goods, for example, can cause safety hazards, especially with respect to electrical products and other kind of home product goods. So it's an area where stepped up enforcement has occurred, and we expect to see that happening over the next little while. On to the next slide, please. Investment. We alluded to that a little bit earlier. Many of Canada's free trade agreements have chapters on investment. They protect investors from discriminatory or arbitrary treatment. And it's kind of nice to know what level of treatment you can receive if you go and invest in another country. I had, for example, a case involving, what was it, a coffee plantation. Some investors, Canadian investors, went and bought a coffee plantation down in Costa Rica, and lo and behold, it was settled by a bunch of rancheros, and they decided that they wanted to have the place for themselves, and the local police department didn't want to do anything. So then they used this local investment treaty to go after the national government to say, hey, you know, we have this protection. We want you to do things to sort this thing out. We don't want to be taken advantage of just because we are Canadians. So that's the kind of thing that you can use if you are aware of it and you, go in with your eyes open. I must say that if you are in a situation where you have to use this type of a provision, it's not a good thing. It's not nobody wins here. So you're just trying to make the best out of a bad situation. On to the next slide, please. Free trade agreement rules of origin. Well, as I mentioned, it's the heart of an agreement. It tells you whether or not goods are originating. The rules outline the proportion of a production that must occur in Canada. And goods that qualify originating are generally eligible for preferential tariff treatment, duty-free treatment in most situations. So that's the name of the game. Determine what are the rules, determine whether or not the goods meet the rules, and then the goods are said to be eligible for free trade agreement, trade agreement treatment. We are seeing, sorry, David, we are seeing many more requests for strategic opportunities. Tariff-free engineering, we sometimes call it. So an example might be, the importation of parts from China, and some from Canada, some from Vietnam, for the manufacturer of, let's say a bus. What does the importer need to do to avoid US duty if they take that bus and import it into the US? What amount of non-originating components can you take from China, for example? What is the value of the originating components that you have to put into the manufacture of the bus? What does it have to change? What is the tariff shift rule? And then what is the result? Can you then claim NAFTA, for example, or USMCA treatment in order to import the good into the United States and avoid any high tariffs on Chinese origin goods? David.
Yeah, I would just say that the main thing is that do not, as a Canadian importer, ever underestimate the willingness by exporters to tell you that their goods qualify under a free trade agreement. Each free trade agreement has its own ways of verifying if the goods are actually deemed to be made in that country. And the thing is, if you don't do your homework, you may find yourself in a case where you've relied on an exporter or a vendor overseas who tells you his goods are made in Korea, qualify as made in Korea, and they come into Canada only to find that under review that the goods are actually made in China, labeled in Korea, come into Canada, and unfortunately the penalty from, in this case, Canada Customs goes to the importer, not the exporter. So you really need to dig into free trade agreements and understand how goods qualify. And it's not something to be taken lightly, because you can certainly, as a broker, we can import goods and claim the free trade agreement. And however, customs in this country has up to 4 years from the date of import to review to see if those goods are in fact qualified. And so you could be incurring a hefty liability, being pent up, and thinking that everything's on board. So it's really do your homework and really have a heart-to-heart conversation with your vendor. Don't pressure certainly your vendors into ensuring their goods qualify. Make sure the goods in fact do qualify for a free trade agreement.
Yeah, and I have to add that the same sort of thing happens when you're exporting to the US. We have a case or two right now that are on the go where the Canadian exporter to the United States obtained a supply of goods from someone, the supplier has said that they were eligible for free trade treatment. And it turned out that the US government disagreed. And they're now advancing an appeal with the US government. And that's not a place where you want to be, right? So then you have to then decide what is your recourse? What are you going to do about this? And one way of protecting yourself is to get, before this all happens, is to get a indemnity agreement. So you say, okay, you give me the certificate of origin. If it's not right, I want to be made whole. Or to get somebody to verify that the necessary analysis has been done to give you an assurance that, yeah, this is going to look okay. That they've gone through the eligibility criteria, and they've actually done the correct analysis, and the goods should meet the rules of origin. So those are two possible avenues. If it's an ongoing supply and there's lots of money at stake, it's well worth it. Next slide, please. Well, I guess this is a little bit more information with respect to the fact that Canada is the US's largest customer, the largest market for something like 15 states. So we have a pretty big relationship. Similar, the US is Canada's largest export market, so much so that the Canadian government has encouraged and tried to encourage businesses in Canada to diversify, to take advantage of these other agreements, to find other markets so that they're not so overly reliant upon the US market. It's very easy to export into the US because of the close proximity, similar rules of law, the same language and all that. But sometimes it's nice to have a second customer so that you're not always stuck negotiating with the same partner. On to the next slide, please. Well, some of the topics that have been big for free trade agreements, we've touched upon a couple here. One is the agricultural sector. It's been a hot topic for the US exporters into Canada, actually. Canada has a very big tariff wall for certain types of goods. Dairy, chicken, eggs, these types of goods. We have what's known as a supply management system. Part of the supply management system is to create a tariff wall to prevent the oversupply of goods into the country. And the thinking is that by having this system of supply management, prices will be managed. Domestic producers will be guaranteed of a viable market, and it will ensure the continuance of farming and agriculture in Canada, that industry. The result of that from a customs standpoint is that there is something known as a tariff rate quota system. You can apply for a quota, so you can import X number of, gallons of or liters of milk or yogurt at a reduced cost if you stay within the quota. If you exceed the quota, then you're subject to very punitive rates of duty, up to like 300% duty. Or if you import without the permit, again, you're subject to these very high rates of duty. So the U.S. House Committee on Ways and Means have published a Trump administration U.S. MCA report card. And the gist of it is that the Ways and Means Committee is not overly happy with the way that Canada has been dealing with certain things. Canada promised to eliminate current milk classes of 6 and 7 and so forth. And this report says, well, hey, they've been dragging their feet, these Canadians, and they've not been doing what they're supposed to be doing. And so we want to see that the US trade representative takes action to enforce what was agreed upon in connection with the USMCA. On to the next slide. Autos, another big issue. The rules of origin were significantly, I would call it, increased or bolstered or made more stringent. There was an increase in the regional value content, the amount of the value of a good that has to come from the North American region. The stronger regional value content requirements for core parts such as engines and transmissions. So there's much more increased requirements. And a new labor value content provision requiring that 40% of the value of a passenger car, 45% for a truck, be made of materials, parts, and labor produced or carried out by workers making $16 an hour or more. Again, the Ways and Means Committee has latched upon this particular issue and said that automakers are continuing to make significant investments in Mexico. And General Motors, for example, has announced plant closures in the US. And the labor value content requirements have really imposed few new costs. So they're not really wildly enthusiastic about the rules of origin. Well, it remains to be seen as to whether or not there will be stepped up enforcement, efforts to change these rules, or other things. David, any thoughts?
Yeah, I would just say that most Canadians are unaware that our biggest sector for exports to the United States is the vehicles. So in 2019, there's $52 billion worth of product that went in the United States. Machinery is like 45 billion. And then the list goes down. So it's by far the biggest export from Canada. And this is a very serious issue, and one that the United States is always threatening with putting more plants within the United States and less reliance on certainly Canada as a market to manufacture vehicles. And it's a big employer and it's a big dollar figure. So something, you know, our firm, we're not that heavily involved in automotive. There's only a couple key players, but it's something that should be on everybody's radar because it commands a lot of jobs. So.
Mm-hmm. Okay, next slide, please. Textile and apparel, another area that is, you know, it's been a big focus, especially we see so much coming from overseas, from places like China, and the duty costs on imported apparel goods is something in the neighborhood of 18%, right, David?
That's correct.
So there are efforts from time to time. We see people declaring, you know, NAFTA or USMCA or CUSMA, and it's not true. And so who gets hit is the importer. So we've had cases where, you know, Canadian importers brought stuff in on the basis of a US certificate of origin, and it turns out that the CBSA does a verification, and they go down to the States and they find that it doesn't qualify, and there's no way of making it qualify. Well, the result of that is what? The Canadian importer has their claim for preferential tariff treatment denied, and so their duty costs go up. And the US exporter has a letter saying your goods, everything that you've exported to Canada doesn't qualify, so you better let your importers know. So it's one of those things you have to get right from the very beginning, because it's very difficult to reverse engineer this and make it fit afterwards.
Yeah, I guess from my point of view, this is the most misunderstood section of NAFTA and now the USMCA or CUSMA, is that, and unfortunately back in 1984, there's a massive lobby to put language within the agreement that prohibited offshore fabric from being used, because at that time, fabric was being created both heavily in the United States and to a certain extent in Canada, and they wanted to force manufacturers to use that fabric. Since that time, the biggest offender was Dominion Textiles, no longer around. This is now something that both countries had to set up quota provisions. So a lot of people are under the misinterpretation that either goods don't qualify for preferential treatment, or they do because they're made within the United States, when in fact there is quota available both into Canada and into the United States if you have manufacturers within those territories making goods from foreign fabric. So this would take, it does take, you know, I do a section that this takes about an hour to discuss with people, but it's certainly the biggest area of misunderstanding for small, medium-sized manufacturers, that there's great opportunities for companies, certainly in Canada and the United States, to manufacture within the USMCA area and still obtain preferential duty rates, even though your goods don't technically qualify for the agreement. So it's just, it's something that I caution everybody. And I was just on a call with somebody this morning on the very topic of it. And it's something that I keep insisting that people need to get more involved in. And certainly when you got small, medium-sized manufacturing institutions starting up, seek to find people that understand how the agreement works and how your goods can be manufactured and still qualify for zero duty. Coming into Canada, our highest duty rate is garments. It's 18%. Going to the United States, you get up to 32, 35% on garments. So huge penalties.
Next slide, please. De minimis. This is the issue of how to get goods in and not pay any duty. So if they're below a certain threshold, the de minimis threshold, there's a phrase, de minimis non curat lex. The law doesn't concern itself with a trifling matter. So anything that's less than, what do they say here, $150 for customs duties and $40 for taxes, GST, are considered a trifling matter. They're not going to worry about it. This has helped some importers of low value goods bring goods into the country duty free. Now, the thing is, with the US, the rates are much higher, right, David?
That's correct. Yeah. Into the United States, that limit is $800 US. So if you look at de minimis rates around the world, some of the smallest ones in the world are Mexico. United States is second largest at $800 US. Australia is $1,000. Canada is in the low group, where we've just gone from $20 to $40, where you're exempt from duties and taxes. And like Dan pointed out, if your goods come out of the United States, and regardless of where they're made, and they're under $150, they can come into Canada without any duties. However, you still would have to pay any GST and or PST if it's applicable. And that $150 level is similar to what's going on in the EU.
So we're seeing quite a few different strategies for taking advantage of the de minimis thresholds. One of the strategies has been to put in a Canadian hub. So you can bring in goods from, say, China, put them in a Canadian warehouse, and then export them onesies, twosies into the United States. If they fall within the de minimis threshold, then you can potentially avoid paying duty on the goods. Another way of, sorry, go ahead, Dave.
Yeah, I was going to say not only just duty, but there is no actual brokerage charged by a broker or customs entry. They actually are cleared on a manifest stream, which the express couriers have. So all the express couriers have, or they're dumping information as far as shipper, consignee, value, and what the goods are. If they're not subject to other government agencies, those goods are deemed to enter into the United States without a customs entry. They're cleared on a manifest stream. So there's no processing. So a great option for small, medium-sized, even larger companies to do their US e-commerce out of Canada.
Right. And then another strategy has been to use foreign trade zone in the United States, have imports into the United States, some designated, say, for Canada, and then have those goods imported into Canada. So that's another methodology. Next slide, please. Procurement. Again, we talked about procurement. It is something that is a big opportunity, but many folks on this call will probably not be too much focused on government procurement. It's really the opportunity to enter into large contracts with the government. On to the next slide, please. Services. There is a streamlined process for dealing with temporary entry for business persons, similar to the way NAFTA has been dealing with things. And so the idea is it's designed to encourage regional integration of business. So if I had a business, I can, incorporate a company down in the United States, maybe a professional services company in legal profession, and then possibly have, myself go down to provide services and build a US practice down there, that kind of thing. On to the next slide. Intellectual property. So there is enhanced copyright protection that is being provided, and that was at the urging of the US and many companies in the US. So there have been some amendments that have bolstered protections for things ranging from data protection for biologics and other types of high investment intellectual property goods. On to the next slide. Dispute resolution. There have been some tweaks. I kind of think that if you're involved in these dispute resolution mechanisms, there's no win, only degrees of losing. And that is the case in, for example, the softwood lumber matter. That is the case that keeps on giving to many lawyers and consultants for the last 20 years or so. On to the next slide. So the United States has free trade agreements in place with a whole list of countries. So the list for the US is going to be different than the list for Canada. And so we provide assistance for folks that are exporting into the United States or from Canada and exporting from the US into Canada, both sides.
Yeah, I guess, and a word of caution is just because a good enters into the United States by one of these trade agreements, and Canada has a trade agreement with that country, you in fact lose the benefit because the goods have not been shipped directly to that country. So just a word of caution. We run into it sometimes as somebody says, the United States has got an agreement with Korea, and the goods came in the United States and they landed in the US and now they're being shipped, so the goods still qualify. That's not the case. There's very few free trade agreements say that goods can be shipped from a country outside of a trade agreement between two parties. So just, I guess, a word of caution.
Next slide, please. Canadian Importers Database, list of companies importing by Canada by product. So you can find out who's doing what as one way of, if you're an importer, you can just determine who's your competition, for example, or if you're a supplier, you can find out who's doing this type of work. So these are sources that are available that are free of charge, that are provided by government entities.
Yeah, and I guess my comments on that, in the United States, there's a massive industry that's dedicated to selling this type of information, but in most cases, it's been manipulated to companies trying to find out the the overall market size and who the major players are. And in Canada, that information is not allowed to be sold. However, when they set up their Statistics Canada, being a public agency funded by tax dollars, that information is available to all Canadians. Once it was available on the web, it's open to anybody else. So I'll give you a live example where I had a client call me to say that they had one of their competitors, who was not someone I was dealing with, that they seemed to be beating them to the marketplace, and that their products seemed to be priced about 18% less than what their goods were. And so I said, well, let's take a look. There you go. I looked on the website. Their name was listed. They're bringing their goods in from China. So I know, because I'm their broker, and also I know that the goods coming out of China, in fact, take an 18% duty rate. I said, well, let's take a look, see if your big competitor. Said, well, they're listed right there under the same HS code, under the same classification. And let's take a look where they're bringing their goods. Lo and behold, they're bringing their goods in. They're making them in Bangladesh. Bangladesh is part of the least developed country classification. Those goods come into the country at zero duty. So we quickly found their 18% prize. And so my client said, I guess next time we send our purchasers out, we'll take a look to see if we can source a vendor in that country. So it's an incredible database that a lot of people aren't aware of. The next slide actually has an active link to it. So anybody on this presentation, you'll be able to go in, and with tariff codes and a little bit of rummaging around, you can actually see market size. You may run into certain areas that either the government is blocking it because it's under a dispute, but they're far and few between. I would say 95% of the imports that are coming in are listed in there, and it's just a great resource site. So we thought we'd put it on the presentation today. So.
Next slide. Questions? Well, I guess, in wrap up, I just want to say that if you have any questions, please follow up with us after this presentation. Off the meter, no worries about that. My takeaway points, I think, for this presentation would be these, that importers can leverage these free trade agreements to avoid overpaying duty. Secondly, there are strategies for tariff re-engineering that can help avoid punitive duties on, for example, Chinese imports, looking at where the goods are sourced, what is the value of the non-originating inputs, what needs to be done to make the finished good eligible, and so forth. And then thirdly, verification of compliance, especially with the USMCA or CUSMA, will be a focus going forward. David had alluded to the fact that in the beginnings of NAFTA, there were many incorrect certificates of origin. There are some estimates that up to 50% of the certificates were bogus. That was coming from the government. So again, I think that the CBP and the Canada Border Services Agency will renew their focus on this issue going forward to verify that importers are actually meeting the rules of origin when they are making a claim for preferential tariff treatment. David, to you.
Yeah, I just want to thank everybody for their attendance. And if you have any questions, drop us a line or give us a call. And I guess one comment on when Dan was alluding to that there's probably more audits on the horizon. Under the USMCA, there's language in there that both customs parties are going to work closer together. So don't be surprised that CBSA is knocking on your door asking about verification of origin on behalf of CBP. So that language is in place. And so a lot of what went on that kind of slipped under the rug in the past under NAFTA won't be, you won't have access to that sort of lax attitude by departments saying, they're on the other side of the border, it's tough to reach them. And in our case, we would see that, CBP would have to apply to Canada Customs to allow them to come in to audit one of the manufacturers in Canada. And without that allowance to come in, they weren't allowed in the country. And I was actually on one case where US Customs arrived at the border. They did not have their paperwork in order, and Canada Customs turned them away. And I was sitting with a client waiting for the people from CBP, and they sheepishly called to say they didn't have their permit, so they were denied entry into Canada, which as a Canadian, I kind of felt proud and I chuckled, but I didn't chuckle on the line with them. But it just shows that the cooperation on the compliance side. So you really need to have people in your corner that actually understand the rules in both Canada and the United States. And so don't be surprised if either CBP is asking about Canadian customs issues in the United States, and vice versa. CBSA is asking you about CBP issues in Canada. So.
Okay, well, thanks everyone for attending. We will plan to put on another Hot Topics Customs International Trade video call in the near future. In the meantime, if you have any questions, please let us know, and stay safe and be well. Thank you very much.
All right. Take care. Bye now.
Bye.